Today, we are going to look at a case that deals with the rights of unborn children to inherit from their parents. This case is called Ex Parte Boedel Steenkamp, and it was decided in 1962 by the Orange Free State Provincial Division of the Supreme Court of South Africa. The case involved a man who died without leaving a valid will. He had a daughter who was pregnant at the time of his death, and she later gave birth to a son named Paul Johannes. The man's estate was divided among his daughter and his two grandchildren who were already born, Gerda and Daniel Johannes. However, the executor of the estate wanted to know if Paul Johannes, who was in his mother's womb when his grandfather died, was also entitled to a share of the estate. To answer this question, the court appointed two lawyers to represent the interests of the two groups of grandchildren, one for Gerda and Daniel, and one for Paul. The lawyer for Gerda and Daniel argued that Paul was not entitled to inherit, because the grandfather's estate was meant to go to his descendants who were alive at the time of his death. He pointed to a phrase in the law that said wat by datum van dood in die lever is, which means who are alive at the date of death. He claimed that this phrase clearly excluded Paul, who was not yet born. The lawyer for Paul, on the other hand, argued that Paul was entitled to inherit, because he was already a person in the eyes of the law, even though he was not yet born. He relied on a legal principle called the Nasciturus fiction, which means the unborn is deemed to have been born. This principle allows unborn children to have legal rights and interests, as long as they are born alive, and it is to their benefit. Based on this, the lawyer for Paul argued that there was no evidence that the grandfather wanted to exclude Paul from his estate, and that it would be unfair and unjust to do so. The judge who heard the case, Judge de Villiers R., agreed with the lawyer for Paul. He ruled that Paul was entitled to inherit from his grandfather, along with his mother, brother, and sister. Furthermore, the judge stated that the Nasciturus fiction applied to this case, and that Paul had the legal capacity to inherit. He also held that the phrase wat by datum van dood in die lever is was not clear enough to exclude Paul, and that it should be interpreted in favor of the unborn child. He cited a decision from the House of Lords in England, Elliott v. Lord Joyce, where the court said that if a testator's intentions are not clear, and he uses words like alive or born in relation to a specific time, and he does not explicitly exclude the child in the mother's womb, it should be presumed that he had no intention of excluding the child from his will. This case is significant because it shows how the law can protect the rights and interests of conceived but unborn children, and how the courts can interpret the law in a way that is fair and just. Additionally, this case also illustrates the importance of having a valid will, and of expressing your wishes clearly and unambiguously, especially when it comes to your family and your estate. If you enjoyed this video, please like, share, and subscribe to our channel. Thank you from all of us at My Advocatus.